Welcome back to this third segment of this law session on public law relating to public order law and state security. Before the break, of course, we were looking at public order law. I want to finish off with that in this first few minutes, and then, of course, we'll move into state security. Now, before the break, we were looking at public order as an area where the police certainly can limit, for example, processions by persons. And when you look at demonstrations, again, the police do have a say in it. I said to you we would look at the case of Tabernacle and Secretary of State for Defense. Let's do just that. In the case, a 2009 case, we see the Women's Peace Camp, which had been established at Aldermaston, which is the atomic weapons establishment at which nuclear weapons were designed. They also tested nuclear weapons there and built them, and had been doing so for over 23 years. Now, there was a local bylaw which prohibited camping and therefore banned the women's camp. Well, in answer to the claim that the state had violated the right to freedom of expression and association and assembly, which the women brought, the Secretary of State said that the restriction was on the manner and form in which the right could be exercised, not a restriction on the right itself. So they were saying, we don't have a problem with them associating and assembling, but the manner and form in which they were doing it is what we were looking at, so we're not attacking the right. Well, the court said, you're splitting hairs here. The court said, we disagree. The manner and form in which a right might be exercised might actually constitute the very nature and quality of the protest in question. And here the court said the manner and form, meaning the protest on the prohibited site, was the protest itself. Also, the Secretary of State's arguments, they said, were weak. The court said that the camp represented no more than a nuisance and it wasn't a threat. So as far as the court was concerned, they could not consider it a violation in respect of the articles, meaning Article 10 and 11. Now, when you look at recent legislation, the Police Reform and Social Responsibility Act 2011, Part 3, and we've got various sections now regulating demonstrations in the vicinity of Parliament. And those are sections 141 to 147. Now, section 141 repeals section 132 to 138 of the Serious Organized Crime and Police Act 2005. It will no longer be an offense for demonstrations to be held without the authorization of the Metropolitan Police Commissioner. Section 14 of the Public Order Act 1986 applies once more to public assemblies in the area. Now, Section 143 of the Police Reform and Social Responsibility Act sets out prohibited activities in relation to Parliament Square. So please, again, have a look at these updates, because if it is that you get some sort of question and you see, for example, the examiner mention in Parliament Square, you will and ought to know that these are regulated statutorily. Let's now turn our attentions to state security. Well, under state security, what we will consider is the nature of threats to state security, and we will look at the role and functions of the security forces. We will see that regulation of the security forces has moved from a non-statutory basis to being set out in a number of acts of parliament, which go back to around about 1985. And what we have had is this culmination in the Regulation of Investigatory Powers Act, and in relation to official secrets, reform of the law as meant rather than a catch-all offense, as in Section 1 of the 1911 Act, there are now various classifications of the types of material which are protected in respect of the term official secrets. Now, the nature of terrorist threats has also changed significantly. Whereas the original threats in olden days and in time past used to be from, say, Irish Republicans, nowadays resources have been diverted into dealing with a sort of global threat of terrorism and looking at the criminal trafficking of drugs and also the trafficking of people. What then is state security? When we talk about state security, in the same way that we look at public order and look, of course, at matters within the state to deal with assemblies and so on, what is state security? Well, while it is necessary that the state has sufficient powers to counter threats to the security of the nation, it is also important that the powers granted are confined to real threats to the state and do not impinge more than is necessary on individual freedom and rights. Now, in order to be able to evaluate the work of the security forces, you have to look at the definition of state or indeed national security. Now, where you have a stable democratic state, national security cannot justify, as it is in a totalitarian regime, for example, absolutely anything that the government wishes to do in order to ensure and guarantee order. The government cannot just have a crackdown and decide that it is going to have, for example, a curfew where persons stay in their home 24 hours a day. That simply is not going to work. It may work in an authoritarian state, but not in a democratic society. Powers must be limited to the extent which is necessary in order to achieve a legitimate objective. What you need to look at when you look at this here in the UK is there is a whole patchwork of statutes which regulate the area, and it is important to be clear which act governs a particular aspect of state security. Now, if you look at the various actors and players within, for example, the area of state security, let's start with the security services. Well, within the security services, we are looking at the internal security services, which is MI5. There's also the external security service, which is, of course, MI6, or the SIS, the Secret Intelligence Service. You also have the Serious Organized Crime Agency, SOCA, and has responsibilities in relation to terrorism. They have responsibilities in relation to drug and people trafficking and money laundering. In addition, of course, to these services, you have the government's communications headquarters, GCHQ, which of course receives and analyzes signal intelligence from around the world. Now, in order to carry out their functions, the security services require powers, which includes the power to enter premises, to search and seize material, to intercept communications. Because if they didn't have the power, for example, to intercept communications, GCHQ simply couldn't work. Now, it is important to understand the scope of the powers which have been granted under statute and the existing controls over the use of these powers. So what you have to look at is, what is the legal framework within which they operate? Well, the security services were established under the royal prerogative. And it was not until 1989 that statute, in particular the Security Services Act 1989, actually recognized MI5, and it provided a definition of the functions of the service and authorization for warrants for operation. Now, MI6 and GCHQ remained outside of statutory control until 1994. So, frankly, when you look at James Bond, may have been going since 1964, but technically he didn't exist because MI6 and GCHQ were outside of any kind of statutory control, and arguably they were nobodies, as it were. But we see a statutory footing coming into play by 1994 when the Intelligence Service Act was in fact passed. Now, the Regulation of Investigatory Powers Act, RIPA, was passed in 2000, and RIPA actually regulates the issuing of warrants and also controls over operational matters, including, of course, the use of agents. Now, the Serious Organized Crime and Police Act established SOCA, and when you look at the type of authorizations that these agents have, well, if you look at Part 2 of RIPA, it regulates surveillance operations and the use of agents. Now, the Act defines what is surveillance in Section 26. Where authorization has been given and action taken within the scope of the authorization, then the conduct is lawful. But if it is outside, then arguably it is unlawful. What happens when you have a complaint, for example, as it relates to the workings of these services? Well, Part 4 of RIPA provides for a tribunal to hear complaints against action taken by or on behalf of the intelligence services. So if, for example, they've decided to bug your phone for no reason that you feel, then of course there is now a framework in order for you to make a complaint. To who are these services and these people accountable? Well, the security services, MI5 and MI6, are under the authority of the Home Secretary and the Foreign Secretary, respectively. So the Home Secretary, of course, deals with MI5, again, because it's internal. The Foreign Secretary deals with MI6 because it is external. Ultimate control, however, lies with the Prime Minister. Now, the Joint Intelligence Committee oversee the work of the services, and they also coordinate operations, and data from GCHQ are also analyzed by the committee. It needs to see who are you collecting data on, why are you collecting data on them, and so there is some form of reporting for all intents and purposes. Now, there is some quasi-parliamentary oversight through the Intelligence and Security Committee, which makes an annual report to the Prime Minister. Now, state security in recent times has had a massive focus on terrorism. Now, terrorism may be defined as the use of force and violence directed towards undermining the authority of the state and its agents. Now, terrorism needs to be distinguished from, let's say, peaceful protest, which is aimed at raising public awareness about a particular cause and seeking a change in the law. The Terrorism Act 2000, as amended, does provide a statutory definition in relation to terrorism. It says, terrorism means the use or threat of action where the action falls within subsection 2. The use or threat is designed to influence the government or to intimidate the public or a section of the public, and the use or threat is made for the purpose of advancing a political, religious, or ideological cause, and if it involves serious violence against a person, it involves serious damage to property, it endangers a person's life other than that of the person committing the action, or it creates a serious risk to the health or safety of the public or a section of the public, or is designed seriously to interfere with or seriously to disrupt an electronic system, you're looking at terrorism. Equally, the Act does look at the use or threat of action which falls within subsection 2, where you are using explosive or firearms or anything like that, then that, of course, will also be defined as terrorism. When we look at terrorism and the legal framework which deals with it, we see that the law relating to terrorism was originally all under the Prevention of Terrorism Temporary Provisions Act of 1974, which was renewable by Parliament annually. Well, the change in the nature of threats from terrorism resulted, of course, in the Terrorism Act 2000, and certainly when you look at the events of the 11th of September 2001, then we see this massive push towards anti-terrorism legislation, and we got, of course, the Anti-Terrorism Crime and Security Act of 2001. The 2001 Act was reformed, and again we see the Prevention of Terrorism Act 2005, Equal Terrorism Act 2006, the Counter-Terrorism Act 2008. We see an extraordinary amount of activity when we look at terrorism. There's an extraordinary amount of legislative activity which has come on board. I want you, of course, to make sure that you have an idea of what these say, what are the important points, and one of the questions you need to ask yourself, is it that this fear or this state of fear has meant that these types of terrorism legislations have been pushed through at warp 9 speed, resulting in human rights violations or the potential for human rights violations? Does it affect human rights, or is there a legitimate aim by the government? These are questions which are certainly academic and you need to be able to answer, for example, when you look at an exam question. We're going to take a short break, When we come back, we will finish off looking at the whole idea of terrorism, and certainly we will conclude in looking at the issue of state security immediately after this break.